This is an appeal in the matter of Monford Management Ltd and AFINA Navigation Ltd.
Yes, good morning. Firstly, can I introduce the two assessors, Rear Admiral Ian Moncrief and Captain Nigel Hope, both from Trinity House. I should like to thank them and Trinity House and Alan, the Court of Appeal listing officer, for being able to arrange this so that, notwithstanding the events of last week, we've been able to restart only 8 days later. Obviously, the assessors are here in consequence of the events last week. We need to make it absolutely clear at the outset that we remain to be shown on what issues the assessors can provide us with assistance. So the fact that we are sitting with assessors is as a result of last week's events, not because the court is persuaded that assessors will be required given the limited nature of this appeal. So that's the first point. And secondly, to the extent that questions are to be asked of the assessors as part of the appeal process, the court would obviously expect assistance on that. And I think I'm right in saying that we don't have any questions from the parties.
My Lord, the usual procedure is that the court will consult with counsel about questions, certainly at first instance.
Yes.
In the light of that, my learned friend and I did liaise about this matter in advance of the hearing. And we put our heads together to come up with some possible draft questions, subject to the fact that it's always a matter for the court what questions the court might be assisted to put.
Yeah.
But if it would assist, we can get those that were polished off and hand them up.
Well, I think it would, because we're very conscious of the principle, which seems to us to be common sense, but there is also House of Lords authority for it, that it is complicating and embarrassing to ask assessors on appeal the same questions as were asked below. So hence the need for, if there are to be questions, properly focused questions. And so, yes, the answer to your question, Mr. Smith, is yes, we would be assisted by seeing any such questions as the parties might want to ask before the end of the appeal, so that if there are issues on them, we can come back to you.
My Lord, I'm grateful. As I say, we have a working draft. Perhaps top and tail it, and I was going to suggest perhaps I have it ready at the luncheon adjournment.
Right. Okay, let me just make a note of that then.
And my Lord, I should say that that is subject to the reservation on both our parts as to the admissibility of those answers, in the sense that, as my Lords know, we say that the advice of the assessors is not admissible in relation to the construction of the rules. My learned friend has a point as to whether any questions should be put going to apportionment, but what we've sought to do is to agree what the questions would be subject to those reservations, in the hope that that will be helpful to the court.
Well, probably best not to comment until we see the questions. Yeah, all right. So, as I say, with thanks to all the people that have made it possible to have an appeal delayed by 8 days, not 8 months, which it would have been the norm, we are in the same position, except there are now 5 of us. We're in the same position as we were last Tuesday morning.
My Lord, yes, and I was going to start by saying the very same thing, to express the thanks of all those on our side of the court, and I'm sure my learned friend's side of the court, to everybody who's made it possible for us to resume so quickly. and with the same panel. My Lords, I had got not much further than the introductions last week. If I may pick up there, as my Lords are aware, this is our appeal against the judgment of Mr. Justice Bryan in relation to the proper construction of Rule 14 of the collision regulations. Those regulations are set out as an annex to a convention, which my Lords have at tab 13 of the authorities bundle, page 214, which amend the collision regulations of 1960, which my Lords also have in the authorities bundle at tab 12. And the preamble to the 1972 convention records, I don't think we need to turn it up, but if I can just say that the parties are desiring to maintain a high level of safety at sea and mindful of the need to revise and bring up to date the 1960 regulations. Rule 14 it appears at page 223 of the bundle. And if I could ask my Lords to have that, because I think to put everything into context, it's useful to look at it straight away. And my Lords, can I pause there to mention one housekeeping matter? My learned friend Mr. Cooper, Casey, rightly pointed out that we had included the treaty version of the convention in the bundles rather than the convention as enacted into domestic law. We have prepared a small supplemental authorities bundle to contain, just for the sake of completeness, both the domestic version as enacted, the French version, which my Lord Justice Nugee referred to last week,
Yes.
the Singapore authority that my Lord Justice Foxton referred to last week, the Savina, the case my learned friend referred to last week.
Yeah.
It was sent to the Civil Appeals Office. I understand it hasn't reached my Lords. Another copy is being printed as we speak.
I'm sorry about that. This building sucks in files. It's always best to contact the clerk of one of us. That's usually the better way of making sure the files get to us. But Lord Justice Nugee's clerk is very helpfully scanning the building, trying to find it. But if another one could be prepared.
Other copies are being printed as we speak, my Lord.
Thank
I
you very
don't
much.
envisage referring to any of the material in it until after it's arrived,
Right.
all going well.
Fine.
And certainly Rule 14 has not been amended.
Yeah.
There's only one rule that has been that we might need to look at, and hopefully the bundles will be here by then. But Rule 14, head-on situation, this was amending what was Rule 18 of the old rules. When two power-driven vessels are meeting on reciprocal or nearly reciprocal courses so as to involve the risk of collision, each shall alter course to starboard so that each shall pass on the port side of the other. B, such a situation shall be deemed to exist when a vessel sees the other head or nearly ahead, and by night she could see the masthead lights of the other in a line or nearly in a line, and or both side lights, and by day she observes the corresponding aspect of the other vessel. C, when a vessel is in any doubt as to whether such a situation exists, she shall assume that it does and act accordingly.
Is there any doubt, Mr. Smith, that the word in 14b is could rather than would? Because at points in the skeletons and I think in the judgment, the word would appears instead of could.
If the word would has appeared, that's an error on the part of whether it's my skeleton argument or my learned friends. It should be could, and indeed, one of the points we don't need to look at in the Travo, but the worse sees was replaced by could see, so it is intentionally could see. Thank you. My Lords, the judgment, we don't need to turn it up at this stage, is in tab 8 of the core bundle, and the learned judge's order is at tab 7. The collision occurred at 06:01 hours local time on the 13th of March 2021 in the western approaches to the Stena Alafinisu Strait. My Lords, there is a copy of the working chart in the supplemental bundle, tab 2. Again, I don't think we need to turn it up, but for my Lord's note, the index doesn't make this clear, but it is the working chart of AFINA I that is in the bundle. Throughout my
So supplementary bundle 2, that's the AFINA I charge.
it's been copied very small, my lords. I don't think we need to look at it in the light of the fact that we have the agreed animated.
Yeah, I think as I indicated last week, one of the things that we had looked at was the animated log.
My lord, yes.
Yeah.
My lord, throughout my submissions, I'm going to endeavour to refer consistently to times as C minus to indicate how far in advance of the collision we're talking. And in particular, my lords, C minus 22 is the time at which the learned judge, on his nautical assessor's advice, concluded that a risk of collision existed. There is no appeal from that, so we are working from the basis that the risk of collision existed as from C minus 22. The appeal is brought pursuant to the permission of Lord Justice Popperwell. His order is at tab 11 of the core bundle, and there are 3 grounds of appeal, 3 principal grounds as set out at core tab 5. The first is that the learned judge erred in concluding that the vessels were in a head-on situation at C minus 22. In summary, as my lords will know, our case is that Rule 14b defines the circumstances in which the obligation to turn to starboard under the rule in 14a arises, and that in circumstances where KIVELI could, we say, only ever see the green sideline of AFINA, and AFINA I could not see KIVELI ahead or nearly ahead, the definition isn't satisfied, and hence we are not in a head-on situation. The third, and I take them out of order advisedly, the third ground of appeal is that the learned judge should instead have concluded that a crossing situation existed and liability should be apportioned on that basis. And I understand that it's common ground that if we're right on ground 1, we win on ground 3. That's why I put the 2 together. There's no halfway house. And then the second ground of appeal is that even if the learned judge was correct to hold that a head-on situation existed at C minus 22, he was wrong to hold that it continued beyond about C minus 745 or C minus 7, and that liability should be apportioned on that basis. My lords, I will be dealing with the substance of grounds 1 and 2, why we say the judge was wrong to hold that a head-on situation existed and wrong to hold that it subsisted until the moment of collision. My learned friend Mr. Carruth will then be dealing with what we say is the correct apportionment of liability if we succeed on grounds 3 and 1 or ground 2. My lords, this is, so far as we've been able to ascertain, the first occasion on which this court has been asked to consider the proper construction of Rule 14. Indeed, the judgment of the learned judge is, again, so far as we've been able to ascertain, the first occasion on which the Admiralty Court has concluded that Rule 14 is engaged. There are at least 2 cases where the court has concluded that it isn't, the Loch Vivek and the MSC Apollo, which I will be coming to later. And the judgment in that sense has generated a certain amount of academic and practitioner interest. The learned editors of Marsden on collisions refer to it extensively in the new 2025 edition, which is in tab 21 of my Lord's authorities bundle. Captain Hurst, whose book on collisions at sea was referred to by the learned judge, wrote an article on it, which we will look at later, which is at tab 22 of the bundle, supporting much but not all of the learned judge's reasoning, and so we'll be looking at that. Captain Thornton, MBE of Hill Dickinson, wrote an article at tab 23 of the authorities bundle, disagreeing, it has to be said, in somewhat trenchant terms with virtually every conclusion of the judge. And then Captain Hurst has produced a counter article at authorities tab 24. So for what it's worth to see the views of those practitioners, we will be taking into excerpts from them.
Are those commentaries generated entirely without any encouragement on behalf of either litigating party?
I can certainly say without any encouragement on our part, my lord.
And the same is true on our part.
Equally, my lords, we have been unable to identify any decided case in the courts of any contracting party dealing with the proper construction of Rule 14, apart from one United States case, which is referred to in Farrell, authorities tab 19. We don't need to turn it up, it's footnoted in Farrell. That decision is in the supplemental bundle. I don't think we need to go to it. It's at supplementary authorities tab 4, we don't believe it takes the debate any further because the case was decided on the facts of the case, but we can look at it if my learned friend feels it helps. And secondly, the Singapore decision that my Lord Justice Foxton referred to last week in the navigator areas. We've all had a look at that. It deals with Rule 14. In my favour, it does refer to the judgment of Sir Nigel Tier in the MSc Apollo without apparent disagreement, but I do accept that the court in that case was not addressed on the correct meaning of Rule 14 and declined to make any findings on it, deciding the case on the facts under the narrow channel rule. But it was an extremely experienced panel of former, at least two of the panel, former Admiralty practitioners in Singapore who did refer without demur to what Sir Nigel said in the MSc Apollo. So I'm going to provide a little bit more detail as to the facts, hopefully fairly quickly, by reference to the plots we exhibit to our skeleton argument. I'm then going to deal with the proper approach to the collision regulations. I will then set out what we say is the proper construction of Rule 14 applying Article 31 of the Vienna Convention. And then, as permitted by Article 32, I'm going to look briefly at the Travo to support the conclusion that we say my lords should come to even without the Travo. And I'll then look at a more granular level at the sub-issues which the learned judge identified at paragraphs 115 and 187 of his judgment, which my lords have seen referred to in the skeleton argument, the definitional issue, the and/or issue, the a vessel issue, and the Rule 14C.
At some point, Mr. Smith, I would find it helpful to know what's on your critical path in terms of which, and don't tell me now, but I imagine there are certain combinations of sub-issue outcomes that you need, and I just want to make sure I understand what they are.
Well, my lord, it's probably helpful if I mention that right at the outset, because the reason I'm going to deal with construction first, then the Travo, and then come to those sub-issues, is because in relation to all of those sub-issues, we say that although obviously I need to deal with them because that's the way the judge approached construction, they don't particularly assist, because what my lords need to be doing is standing back and looking at Rule 14A, B, and to an extent C as a whole. Because on our construction, it's a bit like where do you break into the circle? If you look at any individual bit, there are arguments for and against, and we say what my lords need to do is put the package together. So in one sense, they're all on my critical path, but in another sense, none of them are on my critical path. And if I can explain that, because it may help to see where I'm going, we say that Rule 14B is a definitional provision. 14A is the rule, 14B is the definition. And we'll look at the Travo in relation to that, not least because the delegation that drafted Rule 14B specifically referred to it as the definition. So we'll come on to that later. Assuming it's the definitional issue, so that is essentially on my critical path, we then say it doesn't matter whether you start with the side lights or ahead or the masthead lights. They're all describing the same thing, which is the aspect which the end of Rule 14B refers to that has to be identified by daylight. And if we are right, there are a package of provisions by which the arc of visibility of the side lights is a maximum of 3 degrees either side of the centre line. That defines from where the other vessel would be able to see both lights as opposed to just one light. On our case, it also defines ahead or nearly ahead. That then creates the reciprocity that Sir Nigel Tier referred to in MSc Apollo. Because if one vessel is ahead or nearly ahead of the other vessel, so within the 3-degree arc, and can see both the side lights, the other vessel will be able to. And that then gives one a mathematical answer to what is reciprocal or nearly reciprocal, 6 degrees. And that therefore that package needs to be dealt with as a whole. So, my lord, definitional is on my critical path. I don't stand or fall on definite issue because there are suggestions in the authorities and at least one of the practitioner textbooks that reciprocal or nearly reciprocal is 5 to 6 degrees and no more in any event. But we submit that if 14B is a definitional provision, then everything else follows. And that's why Sir Nigel was right to focus on the requirement for reciprocity in Rule 14 as a whole. So, my lords, I'm going to deal, if I can, fairly quickly with the facts leading up to the collision. The court has been provided with the agreed animated plots, which I know my lords had seen, and both vessels had working voyage data recorders. The data has been downloaded and compiled into an agreed schedule, which is a supplemental bundle, tab 1. We don't need to turn it up. It's quite difficult to read and it's quite small. I'll give my lords the references to it where necessary. And I'm sure my learned friend will check that I'm giving my lords the right figures from it. I'm not going to go to it every time that I refer to it. There are two versions of this schedule. The first supplementary bundle, page 2, which just shows the data from each vessel from C-60 to C+10. The second has 8 additional columns added by my learned friends instructing solicitors during the trial, with some colouring in blue and green. And it might assist just to show my lords that, even if we're not going to look at the detail, starts at tab 1, page 7. And what those instructing my learned friend have helpfully done is to add extra columns, which shows AFINA 1 bearing heading offset away, and then 4 columns further on, KIVELI bearing offset away. And the significance of that is that they've coloured in blue wherever the angle is less than 3 degrees, and in green, I think that the 1 or 2 occasions later on where the angle is less than 1 degree. And therefore the blue cells in either column represent the times at which the ships would have been within the 3-degree arc prescribed by the rules for where the lights have to cut off. And my lords, again, for my lords' note, that's dealt with at Annex 1, paragraph 9A1 of the rules, core tab 13, page 326. So the side lights have to show the red light to port and then a maximum of 3 degrees to starboard, the starboard light to starboard a maximum of 3 degrees to port, and so an arc totaling 6 degrees, either side, 3 degrees either side of the centre line, within which both side lights can be seen. And using that agreed data, we've produced 8 plots showing, we believe, the relative position of vessels at 8 key moments. Those are in core tab 1, if I could ask my lords to have that open. I'm not going to go through all of them, but simply show my lords the most important. At core tab 1, page 31, it is the set of plots and printouts from the agreed reconstruction for C-22. So this is the moment at which both parties accept a risk of collision existed. And at the first page, there are a number of pages for each time. So for position 1, we have at page 31 the screenshot of the animated construction my lords have looked at, and we'll see all the information on that, the position of the vessels and various other vessels superimposed on the Admiralty chart, the radar screens of both vessels, and various other information derived from their data recorders.
Can I ask, looking at the radar screens, what is the line drawn on the screen?
My lord, can I suggest that we go straight on to page 35, because they're slightly blown up slightly larger there. It's just... So the left-hand screen is KIVELI radar.
Yes.
And that is her heading shown on the radar, in other words, where she's going if she makes good her heading. And similarly for AFINA 1, her radar is on the right-hand side, showing AIS data that she is gathering from other ships. So AFINA 1 is the yellow dot with some blue behind it on the right-hand side of the screen. The white line is her heading that she's making at that time. KIVELI
Is it the heading or the course over the ground?
Heading.
The heading. I mean, they're in fact, at that point, I think they're the same. But
The same or almost the same at all times or almost all times. In this case, the difference doesn't make any difference. I appreciate that in other cases
but the
it does.
rules have to be applied in cases when it does make a difference.
Exactly, I understand that, my lord. But in this case, there's very little difference between the headings and the courses. And again, there may be an issue as to course made good or course over the ground. And course over the ground, in this sense, the same as heading. But my lord,
I don't think I've understood the difference between course over ground and course made good. I understand the difference between heading, which is the direction the ship is pointing at any one time, and the course over the ground, which is the direction it's actually travelling over the surface of the seabed.
my lord,
Course made good.
can I show my lords, because it's easier than trying to explain it, a diagram attached to the first of the two articles that Captain first wrote, which is in bundle 2, tab 22, page 442. And he has depicted two vessels there with headings or course through the water, and then their course over the ground or course made good differing from that, illustrating the fact that there may be a risk of collision when one takes into account the course over the ground.
That I understand, but you just said that what it shows is the heading or course through the water, which is CTW, in one direction.
And the current,
Course over ground or course made good is what you said, which suggests they're the same.
my lord, I was using the same course made good, course over the ground, so that the actual, where the vessel is going to move to.
Yes, my question was, what is the difference between course over ground and course made good? And I think the answer is they are the same.
They are the same. Right.
Thank you.
It was course through the water which differed.
Thank you.
And so, my lord, we were in the charts attached to our skeleton argument, and if I can then just explain what they're intended to indicate. At page 32, you see 3 dotted lines from each vessel. One is her heading at the time. The one to the left is the heading plus, sorry, the one above, the heading minus 3 degrees, the one below, the heading plus 3 degrees. So they indicate the arc of maximum arc of visibility of the side lights. And we've coloured that in at pages 33 and 34. So what you see at 33 is that KIVELI is outside, we say, the arc of visibility of the red side light, and is therefore only going to see the green side light of AFINA I, whereas over the page at page 34, we see that AFINA I is within the arc of visibility, not only of KIVELI's port side light, but also her green side light, even though she is to port of the centre light.
I thought when you were opening your submissions, you said one of the points in your favour was that if the 3 degrees was the limit of what head-on, what Rule 14 requires, and if one vessel would see both side lights, the other vessel would also see both side lights. This seems to illustrate that there can be positions in which that's not true.
Well, my lord, I think I said ahead or nearly ahead rather than head on, and it may be a difference from that. But what we say at 33 is that, taking into account that package of results that I described, is that AFINA I is seeing KIVELI fine to starboard, not ahead, because KIVELI is outside the 3 degree arc. And that's what...
But I thought if you look at 34, the one is seeing both side lights of KIVELI.
She is. And she is ahead of KIVELI.
But KIVELI is not seeing both side lights of AFINA.
Because AFINA is seeing her to fine to starboard rather than ahead.
So I misunderstood you when I thought you said that if one could see both side lights ahead, then the other one must also be able to see both side lights ahead. Because here we have a situation where AFINA can see both side lights. You say,
but not ahead. My lord, sorry, I should walk through it again.
I'm sorry, I'm being very slow, no doubt. This may be taking you out of the course you wanted to do this in which case, come to it in due course.
My lord, no, it's helpful. I went to these plots for this reason. My lord, 33 shows that because KIVELI is more than 3 degrees off the heading, the centre line of AFINA 1, in our submission, AFINA 1 is not seeing her ahead. So AFINA 1 is seeing both side lights of KIVELI, but not ahead or nearly ahead. KIVELI is seeing AFINA 1 ahead, but only one side light. Whereas if they were both within the 3 degree sector, they would both see the other ahead and they would both see both side lights.
How does AFINA 1 know KIVELI is not ahead? 34 is what shows what AFINA 1 sees, is it not?
It does.
AFINA 1 sees both side lights. How does it know it's not seeing KIVELI ahead?
By taking a bearing on KIVELI, by looking at the radar, by observing her by all other available means, by plotting her position if necessary. And my lords, I will come back to that when I develop my submissions, but at least we have the idea of the relative position of the vessels that we say matters. So, my lord, position 1 shows the relative positions of the vessels at C-22, when AFINA 1 says, and we accept now that the judge has held that she did first see KIVELI. It was dark, but visibility was good. The vessels were about 8 miles distant, but it's accepted that the side lights and the masthead lights would be visible at that distance, which is in fact more than the rules require them to be visible at. Since the vessels were in sight of one another, this was the moment when part 2 of the rules governing vessels in sight of each other, applies, and that includes Rule 14. So that is the moment at which my lords need to determine whether it was a crossing or a head-on situation. And at C-22, the vessels were about 8.6 miles, nautical miles apart. KIVELI was 4.9 degrees off the starboard bow of AFINA 1, and AFINA 1 was 2.1 degrees off the port bow of KIVELI, shaping to cross her course line and then pass starboard to starboard just over 0.2 nautical miles, 0.22 nautical miles distant. The difference between the reciprocal headings was 7 degrees, and the difference between the reciprocal courses over the ground was 6.9 degrees. And I take all that from the agreed facts and the agreed data, and again, I'm sure my learned friend will pick me up if I'm wrong in that. And we say that it is clear that at that time, AFINA 1 could see the red side light of KIVELI and possibly also her green side light, but that was not ahead or nearly ahead, it was to starboard. And KIVELI could see only the green side light of AFINA 1, even though it was ahead. And my lords then have position 2, which is C-16, which is when KIVELI first saw AFINA 1. And I'm not going to turn all these up, but just give my lords the timing. Position 3 is C-1345. It shows AFINA 1 starting to cross the bow of KIVELI. So she is crossing the heading line, the course line of KIVELI. Position 4 shows the relative positions of AFINA 1 and KIVELI as she completes crossing KIVELI's course line. Can I just ask my lords to look at that at page 50?
And this is C-14.
My lord, no, sorry, C-1330.
So the third position is C minus 1345, and this is now C minus 1330. Yeah.
And you can see there from page 52 in particular, AFINA 1 has crossed the line showing KIVELI's heading. You can still see both of KIVELI's side lights, but not ahead on our case. Position 5 is when AFINA 1 passes outside the arc of visibility of KIVELI's side lights. That's 56 is probably the best illustration of that. She's 3 nautical miles ahead of KIVELI, so she has completed crossing ahead of her, 3 or more nautical miles ahead of her. We can probably skip position 6. It was an issue the judge decided against my clients, and there's no appeal on that. And position 7 shows the relative positions when AFINA 1 commenced her series of slow alterations of course to starboard, and we can see at page 68, she is well to starboard of KIVELI, KIVELI is well to starboard of her. They're still distant about 2 nautical miles. This is when she started to turn to starboard to cross back ahead of KIVELI. And my learned friend produced some what-if plots, which are attached to the learned judge's judgment, showing what might have happened if KIVELI had responded to that turn differently. And they are, if we could turn them up, in the core bundle at page 242. It's a little difficult to see the print because they're small. But at this stage, if AFINA 1 had not altered course to starboard, the vessels were shaping to pass each other with a closest point of approach of about 0.27 nautical miles. And what my learned friend's what-if plots show, that if KIVELI had responded by turning hard to starboard, the passing distance would have been, the lateral separation would have been 184.68 metres. That's the figure circled in the bottom plot. And if KIVELI had not made any alteration of course or speed, the passing distance would have been substantially less than that. And so what we say, 184 metres, is less than 1 ship's length of KIVELI. So by turning to starboard at this stage, AFINA 1 has turned what the learned judge has held a dangerous situation, a passing distance of 0.27 nautical miles, into a vastly more dangerous situation, a passing distance of less than 1 ship's length. My lords, the only other matter I want to show you in the plotting...
Sorry to rise, but I'm just concerned that what isn't clear from what my learned friend said about the plot is that these distances are taken at the time of collision, not at the time we commenced our slow turn to port.
Sorry, not at the time.
We commenced our slow turn to starboard.
I think actually it's a halfway house. I think it's when we turn to port. They're not the moments of collision. These assume we had turned to starboard instead of turning to port. I should have made that clear. So one assumes we held our course, the other assumes we turned to starboard instead of to port, but at the same time.
Yeah.
The only other matter I would show my lord, so we've looked at all the relevant plots in one go, is at page 55. This is position 5, which is C minus 745. Between positions 4 and 5, Cape Natalie, the vessel you can see in green in the middle of the page, that was also approaching KIVELI. My learned friend says head on. turned sharply to port to substantially increase the passing distance between the vessels. And I've shown my lords that because there'll be relevant to some submissions Mr. Carruth is going to make about what was the appropriate thing to do after AFINA I had crossed ahead. So you can see there Cape Natalie having been, roughly speaking, ahead of AFINA I, turning hard to port. My lords, that brings me on finally in relation to my introduction to the facts, to the one factual issue that is in play on this appeal. We don't challenge any of the positive findings of fact that the learned judge made, but we did invite the learned judge to conclude that KIVELI could only ever see the green sidelight of AFINA I from C-22 onwards, at least until after AFINA I's alteration of course to starboard. The judge declined to make that finding. That's dealt with at paragraph 231 of his judgment, page 215 of the foreword. And we submit that he should have done so, and we invite the court to make that finding of fact for 5 sound reasons.
Where's this in the grounds of appeal? Asking us to make a finding of fact?
My lord, it's ground 1.61, where we say that the judge should have concluded that the agreed electronic data showed that neither vessel was yawing, and therefore KIVELI could only ever have seen the green sidelight of AFINA I.
Right, so this relates to 161.
My lord, yes.
Yeah.
And he didn't find to the contrary. He
No, I
just
understand.
didn't make the finding of fact.
Yeah.
And my lord, I've already referred to Annex 1, paragraph 9 of the rules, which specifies the cut-off for the lights. This means that AFINA I's red sidelight could not be seen more than 3 degrees off her starboard bow. And we say the 5 reasons why the learned judge should have made that finding, and we invite the court to make it, is that the plots at positions 1 to 8 are all based on the agreed data, and they all show that from C-22 onwards, KIVELI was outside the arc of visibility of AFINA I's red sidelight. Secondly, the colouring in the agreed data, added by my learned friends instructing solicitors, the blue and the green colouring, reinforces that, because the blue cells illustrate where KIVELI was within 3 degrees of the centre line of AFINA I.
And when you say the colouring, you mean the documents you showed us in the supplementary one?
Indeed, my lord, the blue cells and the green
blue,
cells.
yeah.
The third reason is that, so far as we can see, my learned friend says nothing about this in his skeleton argument, and nothing in response to paragraph 10.2 of our skeleton, where we set out that this is a finding that we invite the court to make. AFINA I doesn't, as far as we are aware, advance a positive case that we could have seen her red sidelight, and hasn't served a respondent's notice saying that the judgment should be upheld on that ground. And in the light of the colouring in the schedule, it would be difficult for them to do so in our submission. Fourth, the learned judge found as a matter of fact that at C-12, KIVELI could only see AFINA I's green sidelight. That's at paragraph 62. And at that time, she was 6.4 degrees.
Paragraph
62 of the judgment, page 173. At that time, she was 6.4 degrees off AFINA I's starboard bow. Given that the cut-off angle is 3 degrees, there is, in our submission, no reason for not making the same finding when KIVELI was 4.9 degrees off AFINA I's starboard bow. The learned judge's refusal at page 231 was based on the fact he said that there was limited evidence. But in our submission, he ignored the agreed factual evidence and data, showing, we say, that in the absence of any material yawing, we could only ever have seen the green sidelight. So we invite you to make that finding, which the learned judge declined to make. And if my learned friend opposes that, I'll deal with that if I can by way of reply.
In terms of how that played out at trial, did you asked the judge to make that finding at trial? And were submissions received in opposition? And if so, what were they?
My lord, I can't assist, I'm afraid, on that. I don't recall it being actively opposed, but it's some time ago now, and that doesn't mean that it wasn't. My learned friend will be in a better position to assist as to whether he actively opposed it. But my recollection is he never advanced a positive case that we could have seen a red sign light as well, which I've already said to my lord.
And as you're always fond to saying to us, you can look at it in your own time.
So, my lords, that brings me on to the proper approach construction, which I hope I can deal with relatively quickly. The first point, as we've already mentioned, is that our submission is that matters of construction are matters of law for the court to determine, see if necessary, paragraph 16 of the Supreme Court's judgment in Nautical Challenger and Evergreen. My lords, it was here that I was going to mention...
Evergreen? Eversmart?
Evergreen is the company, Eversmart is the ship.
Right. Can we keep to the ship name?
I'll call it the Eversmart.
Is that bad?
My
Is
lord,
that
no.
breaching some terrible rule of shipping law?
My lord, no. I think it's probably
I'm
more commonplace to do so.
Eversmart is in my head as being the Supreme Court case. So,
My lords, I will.
so that's 16 of Eversmart's a matter of law.
My lords, yes.
Yeah.
And my lords, we've touched on questions for the nautical assessors. I won't deal with that any further at that stage. Suffice to say that of the three answers Commodore Dory gave the learned judge, of all the answers Commodore Dory gave the learned judge, my learned friend only relies on three in his skeleton. One of them we agree with. That's answer 5. Answer 4 was to do with whether KIVELI would have seen the masthead lights of AFINA I in line or nearly in line. And we directly appeal against the judge's conclusion on that. And we say that, so far as we need to, impugns the answer that he was given. So, my lords, turning back to construction, we have in the authorities bundle the Supreme Court's decision in JSC Polska at Authorities 10. My learned friend and I didn't trouble the authorities bundle with the Vienna Convention because the two relevant provisions are set out in the judgment of Lord Hamlin at page 152. And Article 31 provides that a treaty shall be interpreted in good faith in accordance with the ordinary meanings given to the terms of that treaty and in context of the life and object and purpose. And the context for the purpose of interpretation shall comprise, in addition to the text, including the preamble and annexes. And that's why I referred, my lords, to the preamble, to the convention, setting out the purpose of the convention and then the rules. And then Article 32, recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion in order to confirm the meaning resulting from the application of Article 31, or if that meaning, if applying Article 31 leaves the meaning ambiguous or obscure, nobody's contending for absurd or unreasonable in this case. And then while we have Lord Hamlin's judgment in JSC Polska open, can I ask my lords also to turn on to page 154. At the top of the page, this is in paragraph 32 of the judgment, beginning moreover, confirmation may consist of finding support for a given meaning. It doesn't necessitate the identification of a definite legislative intention. It may, for example, include material which helps identify the object and purpose of the treaty within the treaty. That would be useful aid to interpretation, but is unlikely to disclose a definite legislative intention. So my lords don't have to have, as it were, reached a concluded view as to what the meaning was and then just check it by looking at the Travo. It can assist my lords in confirming the meaning.
So I haven't quite understood how Article 31 and 32 fit together. Is this a case in which either side is saying that Article 32 can be used to determine the meaning because the Article 31 interpretation is ambiguous or obscure?
My lords, I don't think either party is saying that the meaning is obscure or ambiguous, but of course both parties are contending for different meanings. Which
Always say it's to confirm their case.
Indeed, my lord, which is why I took my lord to the paragraph at paragraph 32, because we don't need to go quite as far as to say it's to confirm our case. But again, to put the cards on the table, we say that the Travo showed two things. Firstly, we say that the Travo show that the intention was to simplify Rule 18, to remove some obscure language from Rule 18 and provide for situations of doubt, that's Rule 14C, which there was no equivalent of in Rule 18, but otherwise to retain the principle of Rule 18, and we'll see in the Travo references to the principle, essentially that the relative location of the two vessels relative to each other and the side lights they show each other at night was under Rule 18 and remains under Rule 14 the decisive factor. And allied to that, as I've already mentioned, the intention was that Rule 14b should be a defining provision.
And you'll take us to the Travo in due course, but certainly in contexts such as the Hague Rules, as you will know extremely well, we're often told that it's bullseyes or bust. Is that equally the case here?
My lord, no, and I think Lord Hamlin expressly said as much in JSC Polska that the bullseye or bust approach is not the correct approach under Article 32. And so, my lords, that's the Vienna Convention, and further assistance from the Supreme Court in the Ever Smart, which is at Divider 8. And picking up at paragraphs 37, page 75 is where the Supreme Court deal with it.
Sorry, paragraph
37, my lord. And the history of the convention is set out, paragraph 37, paragraph 38, 39, dealing with the Vienna Convention, which I've already covered. But picking up at paragraph 40 and 41, the object and purpose of the 1972 Convention is to promote safe navigation, and specifically the prevention of collisions at sea. As stated by Mr. Justice Sheen in the Majola 2, we have that in the bundles, but I don't think we need to turn it up at this stage. The structure of the collision regulations is designed to ensure that wherever possible, ships will not reach a close quarters situation in which there is a risk of collision, and in which decisions have to be taken without time for proper thought. Manoeuvres taken to avoid a close quarters situation should be taken at a time when the responsible officer does not have to make a quick decision or a decision based on inadequate information. Those manoeuvres should be such as to be readily apparent to the other side, ship. And then the international character of the collision regulations and the safety of navigation means that they must be capable of being understood and applied by mariners of all nationalities, of all types, professional and amateur, in a wide range of vessels in worldwide waters. They should accordingly be interpreted in a practical manner so as to provide clear and readily ascertainable navigational rules capable of application by all mariners. They are meant to provide international rules of the road. And put it a slightly different way, as the Supreme Court mentioned later on at paragraph 141, which is at page 107 of my Lord's bundles, fundamental, paragraph 141, page 107, fundamental to the construction of the rules is the need to apply them by reference to what is reasonably apparent to those navigating each vessel about the conduct of the other. And that includes in our submission the importance of the side lights referred to in Rule 14b. And we will be submitting to my lords that our construction of Rule 14, which I've already outlined, in contrast with respect to the learned judges, meets that fundamental requirement, because it recognises the need to look at what is apparent to those navigating the vessels and focuses on what each vessel could see, the aspect of the other vessel defined at night by the arc of visibility of her sidelights. Further, our construction, by which Article 14, Rule 14b, triggers the operation of the rule in Rule 14a, is consistent with the observations of the Supreme Court at paragraph 56, which is at page 80 of my Lord's bundle. The Supreme Court in the Eversmart were concerned about whether a crossing situation could exist where one vessel was not on a settled course. And the theme of their judgment was that part 2 of the collision regulations, the rules relating to vessels in sight, seeks to deal comprehensively with all steady bearing cases. So all cases where there is a risk of collision between vessels in sight. And the approach of the Supreme Court is that because Section 2 deals with all steady bearing cases, what that means is that unless you are in Rule 13, overtaking, or Rule 14, head on, you are always in a crossing case, that they deal comprehensively with all risk of collision cases. And in that context, can I pick up halfway down paragraph 56, just below the letter G? Each of those rules, so that's rules 13 and 14, contains precise specifications which trigger its application. See Rule 13b and 14b. So the Supreme Court is referring to 14b as a precise specification which triggers the application of the rule. And in order to make them work clearly at night, the lighting rules, and Rule 21 in particular, operate precisely in tandem with those triggering specifications. And then, by reference to Rule 13, Lord Hamlin and Lord Briggs say Rule 13b, which triggers the overtaking rule, applies whenever the vessel is more than 22.5 degrees abaft the beam of the overtaken vessel. The courses of the two vessels may well be crossing, but Rule 13 overrides the crossing rules. And we accept that if Rule 14 is engaged, it too overrides the crossing rules. But Rule 14b, like Rule 13b, is a defining provision that contains the precise trigger. It would, in our submission, be entirely contrary to the approach of the Supreme Court to have a trigger in Rule 14b and further triggers in Rule 14a. That doesn't meet the requirement of a precise trigger in the sub-rule.
Is that the high watermark of the definitional point in terms of authority? Because obviously everybody knows there are no direct authorities on Rule 14, but some of the authorities on other rules deal with Rule 14, and obviously this is the Supreme Court, and so the precise specifications which triggers its application, see Rules 13b and 14b, is that the high watermark of that point?
My Lord, no, because I will be coming to the MSc Apollo in due case when I deal with the definitional issue. At the moment, I was just looking at the Supreme Court's approach to the construction of the rules. Yes,
but you said it would be contrary for there to be any other triggers other than 14b, because it then wouldn't meet the precise trigger, which is words obviously not in the rules, but in the judgment of Lord Briggs and Lord Hamlin.
My Lord, yes, and Sir Nigel Tier in the MSc Apollo, I think used the phrase "sets the limit of."
Yes,
so 14b sets the limit of. But
if I respect to Sir Nigel, he's not binding on us, but these two are.
My Lord, yes.
They also equate 13 and 14 in that respect, which have, at first blush at least, a broadly similar structure, and including an A paragraph,
and a
B paragraph, and a D paragraph, avoidance of doubt.
My Lord, yes. And again, just to flag up where I'm going, firstly, and I was going to come to this when I dealt with the definitional issue because it more neatly fits in there, but the Supreme Court do refer later on to Rules 13 and 14 as being exceptions to the crossing rule, which is why they need to be precisely defined. But again, one can see when we go to the Travo that 14A originally formed part of 14B was originally part of 14A. It was moved into a separate subparagraph at the request of the Soviet delegation, who referred to it as the definition. But we'll look at that when we come to the Travo. My Lords, two final points on the proper approach construction, if I may, before moving on to what we say the correct construction is. The learned judge took into account what he perceived to be the need to interpret Rule 14 so it could be applied to autonomous vessels. That's paragraph 147 of the judgment. We respectfully disagree. The intention of the drafters can't be ascertained by considering vessels that I was going to say when I wrote this part of my speech that didn't exist in 1972, but as a result of reading the Travo, I noticed that in fact there is a reference to automated vessels deep in the Travo, but it's a reference that says automated vessels must have enough watchkeepers to see what's going on. So not fully automated vessels in the sense that the learned judge meant. But our submission is that if the rules don't work for fully automated vessels, then they need to be amended, not misconstrued so that they apply to that. But in fact, our construction works better for a fully automated vessel because we seek to put a numerical value on what nearly reciprocal, nearly ahead, and nearly in a line is, which is something that an automated vessel can understand, whereas we would suggest be difficult to program an automatic vessel to know what nearly means unless you put a numerical value on it. Secondly, the learned judge at paragraph 150 tested his construction against what would happen in the case of high-speed vessels approaching at a closing speed of 60 knots. And we agree that a risk of collision may arise in relation to such vessels before they are in sight of each other. But the obligation of those vessels is defined by rules 2, 7 and 8. Rule 14 expressly doesn't apply to them before they are in sight of each other. But even if one were applying Rule 14 by analogy, that doesn't count against our construction. Because just as Rule 14 can work during the daylight hours when you can't see the lights by seeking to identify the equivalent aspect, it can apply when you're too far away to see the lights by seeking to identify that aspect, the relevant aspect. And so in our submission, the possibility that high-speed vessels will be at risk of collision before they can see the lights does not count against our construction. So, my Lords, I'll move on, if I can, to what we say is the correct construction of Rule 14. We've already looked at it in the authorities bundle, and I don't propose to take my Lords back to that. Applying the principles that I've outlined, we submit that Rule 14 contains the rule. It sets out what vessels in a head-on situation must do, which is turn to starboard. Rule 14b defines the circumstances in which vessels are, for the purposes of Rule 14a, on reciprocal or nearly reciprocal courses so as to involve the risk of collision. And Rule 14c requires a vessel in doubt to assume that there is a head-on situation. So there are cases to which Rule 14 applies, so there is a head-on situation, and there are cases where one of the vessels is in doubt. That's Rule 14c. And in that sense, Rule 14c complements A and B. It recognises that a seafarer may be in doubt as to whether the precise trigger has been engaged. And in our submission, it's necessary to consider Rules 14a and 14b together because they are both intended to tell the mariner when he or she must turn to starboard, when the positive obligation to turn to starboard has been engaged. And they can and should be read together to create what we say is a straightforward test, even without going to the judge's 3 issues, which I will come to later. And the starting point is that reciprocal, ahead, and in line are all precise terms. If Rule 14 were limited to vessels that were on reciprocal courses, so exactly 180 degrees apart, and were ahead, so not laterally separated or on parallel courses, then the masthead lights would, if there were two masthead lights, if we were over 50 metres, be in a line. That would be easy, but clearly Rule 14 is intended to be wider in scope. That is achieved by the use of the word nearly, as in nearly reciprocal, nearly ahead, and nearly in a line. And it's correct that those terms, or the word nearly, are not specifically defined, but on our case they are effectively defined by Rule 14b, which is engaged when at night, when sidelights are within range, each vessel can see both sidelights of the other. That means that each vessel is within the 3-degree arc prescribed by the rules of the other.
So that provides, on your case, a precise definition of nearly.
Two precise definitions of nearly, because nearly for the purposes of ahead is 3 degrees, but nearly reciprocal then is 6 degrees because of how
Yes,
the
but that's a function of the 3 degrees.
yes, my lord.
So that's a very precise definition of in the English language anyway, a very loose word.
My lord, I accept that, but it is nonetheless a definition that is consistent with the approach that the Supreme Court took to construction of the requirement to construe the rules when they're providing a mandatory obligation to turn to starboard in a way that can be easily understood. And so we say 14b identifies with precision the aspect. And my lords will recall that during daylight, 14b provides that it's engaged when the vessel observes the corresponding aspect of the other vessel. And it is that aspect that is defined, we say.
I sense this is important and I want to make sure that I understand it. I apologise for interjecting, but for my part, I think it would be helpful if you could break down the elements of ahead, nearly ahead, and how they are ascertained, and then how far that is separate from the ability to see particular lights at night. You laid some emphasis on that in explaining the AFINA's ability to see side lights, but not see a vessel ahead or nearly ahead when we were looking at plot 4, I think it was.
Yes. So, the side lights at night are constrained within a 3-degree arc, either side. We say that to be, perhaps if we turn up the plot again. We look at position 1, page 33 and 34.
C minus 22.
C minus 22. So this is the moment at which you have to determine whether it's head on or crossing. And I understand that to be common ground.
The judge found this was a head-on situation at C minus 22.
And continue to be a head-on situation until the moment of the collision.
Yes, but that's because of the C minus 22 position.
And he held that the risk of collision continued until the collision occurred, and therefore
Yes, that's a separate case.
And my lord, it is common ground that, I understand it to be common ground, certainly it is our case, that the court, in the light of the judges finding that the risk of collision arose at C minus 22, the vessels were in sight of each other, and the CPA was too small, that is the moment at which you test. And if it is not head-on, it is crossing. And so what we see at 33 is that KIVELI is outside the arc of visibility of AFINA I's red sideline. That's why we say she can only see the green sideline. And we say, and I accept, of course, what my lord said. Anything said by Sir Nigel is not binding on this court, but he was right to focus on the importance of reciprocity within this rule. We are talking about reciprocal courses. And so what we are looking at is that when considering whether AFINA 1 sees KIVELI ahead or nearly ahead, because KIVELI is outside the 3-degree arc, she's outside what counts as ahead or nearly ahead. So ahead is directly ahead, nearly ahead is up to 3 degrees, 4.9 degrees off the starboard bow is too far to be nearly ahead in our submission. So AFINA 1 is not seeing KIVELI ahead, even though she's seeing both side lights. And KIVELI is not seeing both side lights, even though she's seeing AFINA 1 ahead.
So AFINA 1 is within the 6-degree arc.
Of KIVELI.
Yeah.
Yes, so she can see both of KIVELI's side lights.
Nonetheless should conclude that KIVELI is not ahead or nearly ahead because KIVELI is outside the 3-degree arc. My lord, one could test the matter this way perhaps. Consider a paradigm crossing situation. If AFINA 1 was crossing at 90 degrees at right angles, there would be a moment when she, well, quite a long moment, several moments, when she was directly ahead of KIVELI. So if AFINA 1 were crossing at right angles rather than on a fine crossing course, as we say it is, she would cross and she would see both of KIVELI's side lights, but not ahead. So the fact that A can see both of B's side lights doesn't mean that B is ahead of A. no, well, I mean, I think if you're crossing the T in World War I battleship terminology, that happens, and I think that is Sir Nigel's point in the Apollo. But you ascribe a mathematical test to both.
My lord, and the equivalent mathematical test, the mathematical test, I think I've called it geometrical test, but that takes into account the need for reciprocity. So if the 3-degree angle, the arc, defines when A can see both of B's lights, it also defines when B is ahead or nearly ahead of A.
In which case, and I'm sorry if this is very dense, we have AFINA that can see both of those lights, but KIVELI is not ahead or nearly ahead. That's what I'm struggling with.
Exactly.
How that can be if it's effectively the same test being applied to both. It's a deficiency in comprehension. But
My lord, it's a deficiency in explanation, which is why I mentioned that the right angles. If you are considering what is or is not ahead of AFINA 1, you need to be looking ahead from AFINA 1. And if KIVELI is outside the arc of the 3 degrees, she's not ahead. She's further to starboard than the 3-degree.
And how do you take that bearing? You can do it with a handheld compass, can you?
My lord, yes, or one can look at the radar, one can...
But one of the points Lord Briggs and Lord Hamlin make is that these rules have to be applied to all sorts of vessels, not necessarily over 50 metres equipped with all the latest navigation aids. Certainly not in 1972 would all vessels be equipped with radar. The rules still have to be applied, and the drafters must envisage they could be applied by yachtsmen and small yachts who are manoeuvring under power rather than under sail.
With the benefit of a compass.
So one imagines that even small yachts carry compasses in 1972, but might well not be equipped with sophisticated radar systems.
But my lord, still with the ability, using a compass, to take a bearing on the ship or the vessel, whether it's another yacht or a larger vessel, to take a bearing on that vessel relative to her heading, which is all that one needs to do this. And my lord,
So if you're on the AFINA, you see KIVELI, and you see both side lights.
but it's
So
where
you
you
say-
see them.
You say to yourself, well, there's a risk of collision, there might be. So what I need to do is I need to now take a bearing and see if it's 3 degrees more or less.
I would, yes.
And if it's 2.9 degrees, then I have to apply Rule 14. If it's 3.1 degrees, then I must not apply Rule 14. So that's your submission.
Unless you're in doubt if one or other vessel is yawing, in which case 14C will be engaged. But yes, my lord, that is our submission. When you see the aspect of the other vessel, you have to see where it is. And the other vessel, when she sees your aspect, she has to see where it is as well.
What does aspect mean? Because one of the points, this is where the French text comes in, when the corresponding word is angle. What do you say aspect means?
My lord, how the other vessel presents her lights to you and from where.
So it's both whether you can see both lights and what bearing it is.
My lord, yes. And that's necessary because aspect in the daylight part of the rule is covering both parts of both side lights ahead or nearly ahead.
And what does nearly in a line mean? Because you've given us a precise definition of nearly ahead, which is within 3 degrees or less of directly ahead. What does nearly in a line mean? Because the rule plainly envisages, when you read it with the lighting, that at night you may be able to see both mast lines, if the vessel has both mast lines, long before you can see any side lines. So you must be able to apply the rule when you can't see the side lines. And that depends on whether it's ahead or nearly ahead, she's ahead or nearly ahead, and whether the mast lights in a line or nearly in a line. What does nearly in a line mean?
My lord, we would say that it requires the watchkeeper who is looking at the mast headlights ahead, presumably using binoculars if it's at the distance where the mast headlights are visible beyond the side. And if he considers that subjectively they may be close to what he would regard as nearly in a line, then to carry out the same exercise that I mentioned to my lord, to see whether the vessel is in the right location to be ahead or nearly ahead. It will be defined by the same maths of the 3 degrees.
Well, that would define whether it's ahead or nearly ahead. Does that doesn't define whether the lights are in a line or nearly in a line, because as you demonstrated with the crossing, the T crossing, there will be cases where a vessel is plainly not nearly ahead, but you can see both side lights. And similarly at night, if you're crossing on a T, the vessel is plainly not nearly ahead, but you will be able to see at one point both mast lights in a line. So you can't equate, are the mast lights in a line, with whether you're ahead or nearly ahead. So how do you
But
tell?
you can equate them with whether you would, if you could see the side lights, be within in the 3 degree arc. That's the 3 degree arc for the side lights rather than from the centre line of the observing vessel.
So nearly in a line means in the position they would be in if we could see the side lights, which we can't yet see.
I would guess. And my lord, just to highlight where I'm going to be going to on this in due course, that was the position under Rule 18, and that's why I'm going to take my lords to the tribunal to establish we submit that the intention was to maintain that position. But can I, at this stage, my lords, take my lords to 2 of the authorities that the learned judge was shown, or 2 of the textbooks that the learned judge was shown. In authorities, it's the second bundle, if my lords have got 2 authorities bundles. And I'll take them in order. The first is Farrell, which starts at tab 19, Farrell's Rules of the Nautical Road, and at page 389. The last 4.5 lines of the text. This rule of thumb.
Sorry, page.
389 of the bundle.
Thank you very much.
299 of the book. This rule of thumb is discussed further in the situational ambiguity discussed below, where it is suggested that the weight of authority supports the conclusion that a vessel should now be considered to be on a nearly reciprocal course within the meaning of Rule 14A, only if, when the risk of collision arises, the two courses are within 1/2 a point, 5 to 6 degrees, of being reciprocal. A divergence of more than 5 to 6 degrees would take the encounter out of the head-on situation. Then goes on to say the reader must be cautioned against harbouring unwarranted expectations regarding the ability of the human eye or equipment, and that those are points my Lord Justice Nugee has made. And again, particularly at 8 miles or so, the nautical assessor below gave some advice which we accept in relation to the difficulty of determining the angular separation between the masthead lights at 8 rather than, say, 3 miles. But essentially, what the learned authors of Farrell are saying is that reciprocal or nearly reciprocal is up to 6 degrees, which is the figure one gets to if you apply our 3 degrees either way approach. And then
Is that right? They say within 1/2 point of being reciprocal. They're talking here about the courses being reciprocal, which is not the same as to whether someone's ahead or not.
No, my lord, they're talking about 14A, what 14A means, reciprocal or nearly reciprocal. And they're talking about a difference of up to 6 degrees between the reciprocal of the courses, which is mathematically where we get to if you apply our 3 degrees in Rule 14B.
Is that right? I've read the two courses are within 1/2 point of being reciprocal. If one's going due north, and the other one is going up to 6 degrees off due south.
Off, exactly, my lord. Yes.
Whereas I think you want 3 degrees either side.
No, my lord. So the 3-degree arc of visibility for the lights, then also setting the 3-degree arc for ahead or nearly ahead, equates to a total of 6 degrees off the reciprocal. They all come to the same limit. I may need to draw that out.
I think you might. I'm sorry to be so slab like this. You may need to provide a diagram which explains that. Because at the moment I don't understand it. That's
My lord, can I come back to that, because
Yes.
it's going to take me slightly.
Of course.
I was going to say off course, which would be a terrible pun in the circumstances. And refer my lords to Cockcroft and Lemure at tab 20 of the authorities budget.
Just before we leave that, the 5 to 6 degrees there isn't sourced
Is
in any way.
No.
I mean, I just read the footnote, but that's to do with being in doubt. So that's just their figure.
it's just their figure, but
Yeah.
it is the figure that one gets to applying our approach.
But that's not how they purport to get there, is it? They purport to get there by reference to US cases, which have no doubt heard expert evidence or had nautical assessors or whatever giving in.
My lord, I accept. Cockcroft and Lemure at page 407 say Rule 14, this is just below the top of the two sketches. Rule 14 is apparently not intended to apply to cases in which, from a vessel ahead, or nearly ahead, one side light can be seen but the other is obscured. And that is exactly our point in relation to 14B. The site AFINA I is ahead or nearly ahead of KIVELI, but one side is obscured and only one side light can be seen. It's precisely our situation. So, my lords, my learned friend in his skeleton argument, paragraphs 11A in particular, says that 14A, Rule 14A, creates an objective test to determine when a head-on situation exists, and in our submission it doesn't, because it contains the subjective test of nearly or nearly. What his construction lacks is a definitional provision, which is what we say, my lords, find in 14B. Nearly in 14A, if it is not defined by 14B, may mean any number of things in different contexts. And just to give my lord some examples, at paragraph 126, when considering nearly reciprocal, the learned judge said up to 6 degrees. And he then went on to say, or slightly more. And his nautical assessor answered the question as to what was or was not reciprocal by saying that at certain times, including C minus 22, the reciprocals were within a reasonable tolerance of nearly reciprocal. These are not concepts that are easy for a mariner to understand navigating the vessel on the day looking at lights.
That's what you get with nearly. That's the point. I mean, that's why the definitional point is so important. I mean, nearly could not be, in that sense, a vaguer term. So the question is whether B actually provides a detailed rule. Forget nearly, it's 3 degrees either way.
And whether when 14B itself uses the word nearly,
Ahead and nearly in a line.
that is meant to be precisely
Indeed,
defined.
my lord, I see the point. But just to finish the point I was making, one of the angles that Commodore Dory concluded was within a reasonable tolerance of nearly ahead was 7.3 degrees. And none of this really gives the mariner on the bridge any guidance. Whereas we say, looking at the sidelights and looking at the relative position of the two vessels using the same arc of 3 degrees does fulfill that requirement. Can I have a moment? I've taken quite a lot of what I was going to say next out of turn in answering questions. Can I just...
Sorry.
It's our fault.
My lord, it's more useful to answer...
Two sets of clever questions and one set of dim questions.
Well, my lord has put the judicial finger on the problems with the word nearly very emphatically in our submission. My lords, we appreciate that a test by reference to sidelights may not work for all vessels. And that's a point that the learned judge made, I was going to say against me, he did make it against me on several occasions in argument and in his judgment. A power-driven vessel of less than 7 metres, whose maximum speed doesn't exceed 7 knots, is not obliged to carry sidelights. She may carry an all-round white light instead. That's Rule 23C, which is page 226 of the authorities bundle. But even then, it's still mandatory for her to carry a sidelight if practical. It said she shall carry sidelights if practical. And she can combine the sidelights into a single lantern carried on the centreline. That's Rule 21B. And so, with respect, we think the cases in which there will be a vessel with no sidelights, when we are considering the rules for sea-going ships, are likely to be few and far between and shouldn't drive the construction.
But I'm interested in knowing how you say this works. I mean, it would be sufficient for your purposes for Rule 14B to be definitional in the cases of vessels that carry sidelights, leaving scope for vessels that didn't fall within that to be dealt with in some other way. Or you could say you have to apply it sort of sea prey, or that Rule 14B is really about quite an indirect way of specifying an angle, and you just apply the angle.
My lord, yes, or the other way of putting it, which is how I would have put it, is you still have to identify the corresponding aspect or the corresponding angle if we look at the French text. And there are always going to be some ships, few I suspect, not carrying any sidelights, but there will be some, and I accept that construction of the rules has to cater for them, just as there will be occasions where you see a ship and you can see her masthead lights but not the side headlights, and you have to cater for that. But you are still seeking to identify an aspect, and it must be a singular aspect, because by daylight you have to identify the corresponding aspect singular. And so the masthead rule and the sidelights rule must be defining the same aspect as my lord, I think.
When we come to the Travaux, we'll see that the singular was in there when there was only a singular, because I think the mastheads come in after corresponding aspect is already in the text, so
My lord, yes.
I'm sure there is that much in the singular plural point.
Can I get back? You said there won't be many cases because these apply to seagoing vessels. Am I right in thinking this doesn't only apply on the high seas, it applies to all navigable waters which seagoing vessels can navigate? So estuaries and approaches to harbours, and I mean there may be special rules for navigable rivers and so on, but prima facie these rules apply to quite a lot of bits of water that are not high seas, and where you might well have quite small power-driven vessels. Is that right?
My lord, Rule 1 provides that rules apply to all vessels upon the high seas and in all waters connected therewith navigable by seagoing vessels. So I think that is my lord's point, which would include estuaries and other locations.
Well, I mean, the River Seine has seagoing vessels all the way up to Rouen. And
my lord,
there are probably special rules for the River Seine, but in practice, those are waters navigable by seagoing vessels.
my lord, yes.
And they're very different from the high seas.
Indeed, but that's why I took my lord's too, that the requirement for sidelights, vessels below 7 metres, with a maximum speed of up to 7 knots. My lord, and again, I accept that around the edges there are going to be some issues. We do submit that corresponding aspect can still be identified, but equally we do rely upon the fact that the cases where there are going to be no sidelights, which we say is the primary method of defining the aspect, are going to be vastly fewer than the cases where there are 2 masthead lights, because that's 50 metres and above is the requirement to carry the second masthead light. And that really just illustrates the point I was making a moment ago to my Lord Justice Foxton, that you are still going to have to identify, if you can, using all available means, as the rules require you to do, the corresponding aspect, the aspect that corresponds to the one that is clearly defined. Ultimately, that's what our submission comes down to. There is an aspect that is clearly defined, the ability to see both sidelights ahead or nearly ahead. And the other elements of 14b require you to identify by whatever means you can the corresponding aspect.
One of the points made against you is that your 3-degree angle is the maximum of a permissible range, is it, of 1 to 3 degrees, where you can see the port sidelight out to starboard and so forth. Should a vessel be working on the basis that it's not when it can see the sidelights, but when it would see the sidelights where they set at the 3-degree level? How does that work?
My lord, the rule, as my lord has said, is that the sidelights have to achieve practical shut-off between 1 and 3 degrees. So there is always going to be 1 degree across the centre line and up to 3 degrees. And again, I accept that uncertainty could cause some doubt. But again, it comes down to the overriding obligation on the officer of the watch to use all available means to observe the other vessel and assess whether a risk of collision exists. So you can't say, I can only see 1 sidelight, that's an end of the matter. You still have to use all other available means. And if you see only 1 sidelight, but from plotting the position of the other vessel or taking a bearing, it's apparent that that's because the other vessel has got sidelights closing off at 1 degree, so you're 2.5, 3 degrees, 2.9 degrees to use the example my lord gave me. You would still be required to conclude that you were head on. And I have to accept that that's a difficulty with my construction, but it was a difficulty with Rule 18, and it's a difficulty that's inherent in the sidelight issue. But it's still less of a difficulty than trying to use the word nearly as a precise trigger. So, my lords, I accept that there are points that can be taken against me. They have been by my learned friend. But one still has to identify what is the best precise trigger or the most precise trigger. And that is the aspect defined in Rule 14b. And of course, if in doubt, Rule 14c will oblige the vessel that's in doubt to turn to starboard. So in our submission, Rule 14 applies when vessels are in the same locations relative to each other, as would have engaged the old Rule 18. i.e. they can see both side lights at night. The flexibility of Rule 14c is new, but the basic principle is the same and defined, as I said, by what the officers of the watch can see. And perhaps, if I can ask my lords to look at the article that Captain Thornton wrote on this, because I'm not a voice in the wilderness on this. At Authorities 23, page 459. In the right-hand column, where he sets out essentially the debate we've been having, and then says it would follow, therefore, that a clear visual limit of nearly ahead would be better to coincide with the maximum mark of seeing both side lights, which is at most 3 degrees either side of right ahead. If both vessels were in line with the extremity of the 3-degree cutoff and was able to see both side lights, the corresponding maximum difference in reciprocal courses would be 6 degrees. And that's the point I was making to my lord that I may need to illustrate. For uniformity, and one could substitute for the word uniformity reciprocity, because that's the word Sir Nigel used. For uniformity, the limit of masthead lights being nearly in line within the meaning of Rule 14b ought also to coincide with the same angular limits of the side lights. However, this does not take away the freedom of the mariner to act under Rule 14c when in doubt. In our view, this point about how important side lights are for all mariners to determine when there is a head-on situation is overlooked, and he means overlooked by the learned judge. And in our submission, that correctly summarises the position. So if I can move on then, finally, to submit that our case on the proper construction is supported by such authorities as there are on Rule 14. The first is the decision of Mr. Justice Clark. I accept, obviously not binding on this court, but nonetheless a highly experienced admiralty practitioner and judge, as he then was, at Authorities tab 6, page 42. Summarise the facts as quickly as I can, and hopefully accurately. At the bottom of page 42 in the left-hand column, we see Mr. Justice Clark concluding that Loch Vivek was on a course made good of 345 degrees. He then goes on at some length to find that there's no reliable evidence about anything going on board Common Venture. It appeared that her scrap log, her fare log had both been written after the events, that the entries on her charts were equally unreliable. All the documents had been essentially cooked. Likewise, he held that the evidence of the officer of the watch as to bearings could not be accepted. That's at page 48, opposite the punch hole on the left-hand column. But Mr. Justice Clark assumed, for the purposes of assessing whether it was a head-on or crossing situation, that the courses were those given by the Common Venture's officer of the watch, which is 157 degrees, and then 152 degrees. That's at page 48, the left-hand column. Not the bottom part marked in bold, but the part immediately above that. And he then stated that the question that arose was whether in either of those cases, so Common Venture on 157 or 152, Loch Vivek on 345, whether in either of those cases, quote, Loch Vivek would have been able to see the red side light of Common Venture or common venture would have been able to see the green sidelight of Loch Vivek. So Mr. Justice Clark was answering the question of whether it was crossing or head-on by reference to whether the vessels could both see both sidelights of the other. That was the test he applied. To rule out any questions of uncertainty, Mr. Justice Clark then asked his nautical assessors how much either vessel would have been yawing and whether, based on such yawing, common venture would have been able to see the green light of Loch Vivek and Loch Vivek would have been able to see the red light of common venture. And we can see from the right-hand column at page 239 that Mr. Justice Clark specifically asked them to consider that question on the basis that common venture was steering 157 degrees. So before her change of course, so when the reciprocal difference between the reciprocals was 8 degrees. So he was posing the question on the terms most favourable to common venture as to whether there were any circumstances in which the vessels would have been able to see both sidelights. And the answer was no, and Mr. Justice Clark concluded accordingly it was a crossing situation. But the significance of the case is that his questions to the nautical assessor, indeed his formulation of the question he asked himself, presuppose that it is necessary to consider whether both vessels could see both sidelights. And we also submit that our construction is, as I've said, supported by...
So I'm sorry, I'm sure this isn't a case about Rule 14.
It's a case where Mr. Justice Clark concluded it wasn't about Rule 14 because it was clear that neither vessel could see both sidelights.
Yes, so the point of principle that we get from this case is what? Where do we find that? I mean, I can see the findings on the facts, but what's the point of principle?
The point of principle is that in determining whether or not it was a head-on situation, which effectively would trump the crossing rules, the test that Mr. Justice Clark applied was to ascertain whether either vessel could see both sidelights of the other. So he was applying the test that we say should be applied under Rule 14b.
Where does he say that that's the test he's applying?
Bottom
14b.
Bottom of the left-hand column, in page 48 of my Lord's bundle, the question arises, this is in order to determine whether it's crossing or not, whether in either of those cases, Loch Vivek would have been able to see the red sidelight of common venture or common venture would have been able to see the green light of Vivek. And he then answers that question in the negative. But to put the matter beyond doubt, he asks his nautical assessors whether the yawing could have made any difference.
Yeah, I get that. But where does he address the point of construction?
What it says on page 49 in the left-hand column, about halfway down, is I do not think that it was argued that if the difference between the courses was 8 degrees or more, ships were meeting on reciprocal and only reciprocal courses were in the meaning of Rule 14. So what he's doing is identifying how far they diverge, to what extent the courses are reciprocal. Having decided it's 8 degrees, he says, well, it's not suggested it's within Rule 14, in which case I don't understand what the reference to the lights is doing.
Well, my Lord, simply, I can't put it any higher than this, and I'm sorry if it appeared that I was seeking to, but in considering whether it was a crossing situation or not, Mr. Justice Clark considered it appropriate to identify whether either vessel could see both sidelights. I can't put the matter any higher than that.
Okay.
But that is the test, referred to by Captain Hurst in his article subsequently as the both sidelights test. And it's clear that that is the test that Mr. Justice Clark was applying. My Lords, I was going to then refer to the Supreme Court decision in the Eversmart, but I think I took all of those points when I was dealing with that earlier. I will then ask my Lords to look
Yes,
into
so the Eversmart is the what is it, precise triggers language.
precise
Yeah,
trigger,
yeah.
and Rules 13 and 14 are exceptions to the crossing rule that need to be precise. If I can then ask my lords, appreciating that it's not binding, but nonetheless of some assistance to my lords to look at the approach of Sir Nigel Tierney.
Oh, yes, absolutely.
Again, a highly experienced admiralty practitioner and judge, and his judgment in the MSc Apollo is at tab 11, page 173. And looking briefly at the head note, because it's an entirely accurate summary of the crucial point at paragraph 6, with a difference of 17 degrees between the vessel's reciprocal headings at C-12, the suggestion made by Apollo would be rejected that the vessels were on nearly reciprocal courses and that instead of a crossing situation, it was a head-on situation. And then, crucially for our purposes, the alignment test in Rule 14b must be met by both vessels. And the point in Apollo was that Sydney could, at C-12, see both of the sidelights of MSc Apollo. And my lords, there is a plot at page 192 that illustrate the position. They're quite small. My lords, that you see the Sydney on the left and MSc Apollo on the right. And the lower of the plots is from C-18 onwards. My lords, if it would assist, I can provide after the luncheon adjournment the non-official law reports have got these plots in a much larger version. If it would assist, my lords, we can get some colour copies of those. But at C-12, Sydney could see both sidelights of Apollo. And counsel for Apollo said, well, because of the deeming provision, as she put it, in Rule 14b, that meant this was a deemed head-on situation, not a crossing situation. And she relied on that argument in opposition to the suggestion that her client's vessel, Apollo, was the crossing vessel that was the give-way vessel. And so Sir Nigel had to consider whether 14b, as a deeming provision, if it were a deeming provision, would be engaged where only one vessel could see both sidelines, because indisputably in that case, one vessel could see both sidelines. And Sir Nigel, in reaching his conclusion that Rule 14 must be met, the alignment test must be met by both vessels, specifically referred to and relied on the judgment in the Eversmart. And so the position was that Sydney submitted there was a risk of collision at C-12, with Apollo being the give-way vessel. That's paragraph 71 at page 179. At C-13, the vessels had been crossing but at a safe distance. By C-12, because of a gradual alteration of course, the risk of collision had arisen. And we see the submission made by counsel at paragraph 86, page 181. Counsel for Apollo submitted that the premise was flawed. This is the basis of the nautical assessor's advice based on it being a crossing situation. Because it ignored that at C-12, Sydney could see both the sidelights of Apollo and that action was required of Sydney. And he then says that was an argument advanced at the hearing and I deal with it below. And he deals with it at paragraphs 97 onwards.
Yeah.
And that's the part we relied on, and it's the part, as my Lord Justice Foxton identified, has been referred to by the Court of Appeal in Singapore. My Lords, I don't want to spend time reading the whole of this part of the judgment.
Well, it's 97 to 106 is the whole passage, and certainly I marked up 101, the top bit of 102 and 103.
My Lord, I'm grateful for that indication. In particular, we rely
certainly
on,
we don't require you to read out laboriously any.
grateful.
I mean, are there any other parts of that that we need to have particular regard to?
My Lord, no, the two paragraphs I was going to refer my Lords to were the second half of paragraph 101.
Yeah.
Beginning rules 14A and 14B must be read together. That's a point I've already made. the reference to 14B setting the limit of 14A, and then 104, the particular point raised by counsel submissions could not have arisen in relation to Rule 18. And again, that's the case on our present case. And so, my lords, in our submission, we say that the fact that AFINA 1 could see both of our sidelines when she could see them is not sufficient to bring this within a head-on situation in circumstances where we clearly could not see both of hers, and in circumstances where, if we are right, as the package of 3-degree arcs, if I can put it that way, AFINA 1 could not see us ahead or nearly ahead when she could see both of our sidelines. And so, my lords, that in our submission is the correct approach to the construction of Rule 14 and the correct construction of Rule 14. I'll come back later to just deal with the 3 sub-issues, but if I can refer now to the Travo.
Well, just before we go, because we're looking at the Travo to confirm, as I understand it. But just before we do that, do any of the authorities grapple with the proper construction of the expression such a situation shall be deemed to exist? I mean, the point that I've got in mind is this: as an ordinary matter of construction, if you have a rule or a statutory provision which has a general provision, which is A, and then B says deemed, it's not usual to say that B is effectively the only situation in which A can arise, because it's deemed. So there's a situation where it's deemed to occur, but it doesn't necessarily mean it couldn't occur in other situations. Does anybody grapple with that point of construction?
My lord, not in the context of the collision regulations. We have included in the bundle, for what it's worth, a decision of the Court of Appeal in a different context, in a case called the Karen Battis, where Lord Justice Lloyd made some observations about the use of the word deeming meant.
This is freight deemed earned.
Sorry?
Freight deemed earned.
Freight deemed earned, my lord, yes. Where
Bit of dry
essentially,
shipping at least.
but my lord, essentially, it was on the question of the phrase freight deemed earned, and Lord Justice Lloyd, it's at page 22 of the bundles. The arbitrators, he said, halfway down the page, evidently attached significance to the verbal distinction between deemed earned and earned. With respect, I don't think there is any difference between earned, deemed earned, or considered as earned. But, my lords, it doesn't take the debate very much further.
No, but in the context of the collision rules, as a matter of interpretation, that's not a point that is the subject of judicial consideration, or indeed consideration by the learned authors that you've taken us to, of the numerous texts and articles about collisions.
My lord, save that I will be coming back. I've taken you to the passage in Captain Thornton's article where he takes the same approach as we do, that this is a package, and that essentially presupposes that it is a defining provision, not a deeming provision. So in that sense,
Yes.
That's his position.
Yes, because you do have to read, don't you, effectively deemed as meaning defined. I mean, that may be, in overall circumstances, the right interpretation, I don't know, but that's effectively what you'd have to do.
My lord, yes. And when I come to deal with the definitional issue on a granular basis, if I can come back to it then, because there are other provisions of the rules that use the word deemed that make it clear they're not using the word deemed in the sense of deemed contrary to the facts. And indeed, there is one reference in the Supreme Court where they refer to one of the other deeming provisions, not 14b, and say that may be couched as a deeming provision, but it is not a deeming contrary to the fact. But my lords, can I come back to those when I deal with the definition?
Just before we go to the travel, can I ask you, this is a point I should say that my Lord Justice Nugee had raised with me, which has been troubling me since he did. And it's this, that is 14b concerned with course over ground? And where that differs from heading, how does that create problems if it is exhaustive, if the headings of the vessels are such that may affect the aspect that they can see of the other, but the courses over ground are such that they are heading straight for each other?
It's 14a, which uses the word course. Course or reciprocal, no reciprocal course.
My lord,
But does that mean heading or does it mean course over ground? I think the Eversmart suggests course means course over ground.
the Eversart doesn't just suggest, but in the context of the Eversart says course means course over ground. In our
In
respect,
which case we're bound by that, are we? Or at any rate, we're likely to give great weight.
well, my lord, with respect, firstly, no, and secondly, it doesn't matter for our purposes. The reason I say with respect, no, is because the Supreme Court was considering the question of whether the fact that the vessel, I've used the word crossing, so I'll presuppose the answer, but the fact that the vessel crossing the entrance to the narrow channel had not come onto a course mattered. And they were a steady course. And they were considering whether the fact that the vessel crossing across the mouth of the narrow channel was not on a steady course. That was the question they were asked to consider. Shall I take it out of turn and take my lords to it?
Well, I mean, and it's not my question, it's my Lord's question, but at some point, you ought to address it. But if this is not the most convenient point, then do it when it's most convenient.
My lord, I was going to come on to it, but in essence, the submission is the Supreme Court was considering whether the fact that the vessel crossing across the narrow channel was not on a steady course meant that the crossing rule didn't apply. And the question that the two questions that were for which there was permission to appeal in the Eversmart used the word course in the question. And the Supreme Court was considering course in that context, not, or at least not necessarily, in the 14a context. But in any event, in our submission, it doesn't matter. If
So in your submission, what does course, reciprocal course in 14a, does it mean heading or does it mean course over ground? And we know that in this particular case it doesn't make any difference, but there are cases where it may make a difference. You showed us the diagram. Indeed, it would make a difference.
my lord, yes. The submission is twofold, and I'll come back to it. Firstly, course in 14a means course through the water or heading, because it is defined in 14b.
You have to say that, don't you? Because otherwise 14b doesn't work. Well, extreme cases.
In extreme cases, 14b, well, it's not that it doesn't work, my lord, because 14b is defined by reference to heading. It has to be, because you're looking at the aspect and the aspect of the lights you can see. And 14b, therefore, can stand alone by reference on our construction, even if 14c means course, because 14b, it doesn't fail in its mission. It still defines when the situation exists for the purposes of the rules. It still gives a clear clear definition of when both vessels must turn to starboard. And if they don't, it is then in crossing situation the giveaway vessel must still take avoiding action. So it doesn't undermine the effectiveness of our construction. It just means that the dividing line is drawn somewhere else. So if when we're looking at Captain Hurst's sketch at page 442 of the Authorities Bundle, tab 22, it would simply mean that this was a crossing situation to avoid the risk of collision, rather than a head-on situation.
even though if you look at the course over the graph, vessels are on directly reciprocal courses, and they are heading directly for each other.
I can't shy away from the fact that that is the logic of my submission, but in our submission it doesn't matter, because you still have a precise trigger for which rule applies that would require the vessel with the other on her starboard side to give way, and would require the other vessel to hold her course and speed, and that they know where they stand because of that precise trigger, which is by reference to their headings or course through the water. So, my lords, if I can move on to the Travo, we've looked at the circumstances in which the court can have regard to the Travo. Our submission, as I've said, is that Rule 14 applies the same test as to the relative location of the vessels, the location of each relative to the other, that Rule 18 did. In that respect, can I, because I think now it's helpful to look at it, ask the court to look at Rule 18, which is at Authorities tab 12, page 207. And Rule 18, in summary, only applies to cases where the vessels are meeting end-on or nearly end-on in such a manner as to involve the risk of collision. It doesn't apply to two vessels which must, if both keep their respective courses, pass clear of each other. The only cases to which it did apply were when each of the two vessels is end-on or nearly end-on. In other words, and those are the words used in the rule, and we suggest that what that means is that what follows the words in other words is explanatory or defining to cases in which by day each vessel sees the masts of the other in a line or nearly in a line with her own. So that's a somewhat different test to the mast test under Rule 14b. And by night to cases in which each vessel is in such a position as to see both the side lights of the other. Essentially, that is the latter test, the nighttime by reference to the side lights test, on our case is the same as the test in Rule 14b, because there's express reference here to both vessels seeing both lights, but no reference to a head. And if we're right as to what a head or nearly a head means, it has the same effect. You end up with both vessels being required to see both the side lights. And then there's a long list of circumstances to which Rule 18 does not apply. By day to cases in which a vessel sees the other ahead crossing her own course, or by night, and I'm not going to read them all, but what we say is that the concept of end-on was precisely specified by reference to both vessels being able to see both side lights at night.
You said the rule didn't use the term ahead, but in fact, at the very end, it does, where both green and red lights are seen anywhere but ahead.
But, yes. So, my lord, what I meant by it didn't use the phrase ahead, I meant in the section that I was calling the defining section, yes, it did it by reference to both vessels. But in one sense, that proves my point, my lord, because where one vessel is not observing the other ahead, then she isn't, on our case, and isn't under Rule 18, seeing both side lights. So, my lord, the difficulty with Rule 18 was that it contained a large number of provisions saying it when it didn't apply, and it did not admit of any doubt. It did not say what the mariner would do if he or she was in doubt. And so if any of the "it does not apply" situations was triggered, the mariner was forced to conclude it didn't apply, whereas 14c gives some flexibility. So looking at if we can, at the Travo, we have these in volume 2 of the authorities bundle, but by no means all of them. But the parties considered to be relevant, and there's a couple of references in Captain Thornton's article as well. But the discussions about the possibility of amending the 1960 regulations began in 1966, but the genesis of the new rule as we see it begins in April 1970, the 9th session of the IMO subcommittee on safety of navigation, which you have the papers for at tab 15. The subcommittee considered submissions that have been made by various states, and we don't have those, but actually Captain Thornton has quoted a couple of them, if I can refer to that. So Authorities 23, page 453. So he's referring then to this meeting in April 1970, and he says at the bottom of the page, the Netherlands considered that Rule 18 is basically right and should be retained in principle. However, the wording was considered lengthy and it was considered very difficult to formulate exactly what is meant by head-on or nearly head-on encounters. If possible, the rule should be more concise. The rule lays too much emphasis on cases where it does not apply. It should state more explicitly the cases to which it does apply. And the USSR noted that one of the major deficiencies was that there is no clear indication as to the application of Rule 18. This leads to some uncertainty in responsibilities. In summing up, the USSR states that when revising the manoeuvring rules, present principle of judging the vessel's rights and obligations, depending on their relative location, should remain unchanged. And that, in our submission, is what Rule 14b does. For this principle provides the most simple and clear analysis of the situation. And then if we go back to the actual Travo, we can see at Authorities 15, page 286. This is an annex to the working papers for the meeting, which summarises some provisional conclusions on certain basic principles concerning the revision of the collision regulations. So these are conclusions that have been reached after reading all the submissions, including the two that I took my lords to. End on the situation, the principle of Rule 18 should be maintained, but the present text should be shortened and simplified as far as possible. And principle, we say, in that context means defining end-on or head-on as it is now going to be by reference to the relative physical location of the two vessels. And the next meeting of the working group was in October 1970. And prior to that meeting, the Soviet delegation again prepared a paper which we have at 311, where they make the general comment at page 312 that the provisional text, this is about halfway down the page, the provisional text of this section prepared by the working group need to be developed and more precisely expressed. And then in relation to the section 2, the rules we're concerned with, at 314, at Roman 2.1, supporting the proposal by the working group as to the simplification of the existing Rule 18, we are of the opinion that the definition of head-on, as given in Rule B23, needs precising. Now, we don't have Rule 323, B23 as
Is
it
it
was.
precising or precising in the sense of shortening? One of those actually being a word.
You may have CB, you only have CB2/3, page 323, if that's the case.
I'm grateful. No, that's a later version. So my lords, to unpick this, can I ask my lords to look at page 341? This is 20th of November 1970, and it's a note by the Secretariat summarising the discussions that have taken place. 341, actually beginning at 340, you can see what is then the draft of what is called Rule B23. And at this stage, we see A, very much in the terms that we're familiar with when two power-driven vessels are approaching stroke meeting. And there's a debate about which word is going to be used. But then over the page, what we can see is in square brackets, such a situation can be determined by day by observing the aspect, or by night by seeing both sidelights of the other vessel. And then outside the brackets, but underlined, such a situation shall be deemed to exist when a vessel sees the other ahead or nearly ahead, so that by night she sees both sidelights and by day she observes the appropriate aspect of the other vessel. And then B is what becomes C. And if we look down at little 3, it was considered an improvement to substitute the following slightly amended text from the USSR for the last sentence of paragraph A. And then we see such a situation and the same text we've just looked at. So what has happened is that the original B23 had the wording in square brackets. The Soviet delegation, as we've seen, have referred to that as the definition of head-on, and have said that it needs precising, and have proposed a new wording. The new wording in the Soviet paper is at page 323, and it is that new wording that we then see at page 341.
Except the word each has been replaced with the word a.
Indeed. But my lord, for these purposes, the submission is that both the Soviet delegation who revised this provision referred to it as a definition. And if we go back to page 341, 342, the notes of the Secretariat, at 342, little 5, they say at this stage attention was drawn to the necessity of having the rules in the following sequence: overtaking, head-on, crossing, because of the definitions. And they make the point that if separate definitions are adopted for overtaking, head-on and crossing, the sequence can be changed. So what the Secretariat are saying is that the overtaking and head-on rules have both got definitions within them. And the definition is the text that the Soviet delegation referred to as a definition and proposed improving, is the word the Secretariat used.
But actually removing definition, because the bit in square brackets on 341 is a definition. Such a situation can be determined by day by observing the aspect, or by night by seeing both sidelights of the other vessel. Clear, simple, definitional. So whatever the Russians called it, with great respect, actually, potentially it's something else. Although, I mean, there are lots of other points, I accept that. But you see the point. The bit in square brackets may even meet the Dutch point that it needed to be simple. Anyway, there it is. So that's where we got to here.
My lord, just to answer the point, my lord, because it is covered, if we go back to 314,
Yeah.
the last sentence at Roman 2.1, the proposed text of the definition. So the Russians are proposing what they regard, what they view or understand to be a definition.
Yeah.
And it may, because of the use of the English word deemed, not seem as much like a definition as the previous provision. But clearly, the Russians intended their wording to be the definition. And it is that wording that was considered to be an improvement by the delegates.
Can I go back to the point about each vessel and a vessel? Because Rule 18 plainly proceeded on the basis that each of the vessels has to satisfy the requirements of the rule. And so does the Soviet text, which we see at wherever it was, 323, when each vessel sees the other ahead, so that by night she sees both sidelines. But when we get to the text and the note by the Secretariat at 341, which describes it as a slightly amended text, each vessel has been replaced by a vessel. So that looks like a deliberate change. What is the purpose and what is the effect? Because that's the text we have, a vessel, not each vessel.
My lord,
In your submission.
the position is that because unlike Rule 18, when it was referring to sidelights, Rule 18 didn't have a requirement in the definitional bit to be ahead or nearly ahead. Because of the inclusion of the word ahead or nearly ahead, you don't need each vessel, because if one, this comes back to the point I was making earlier, if vessel A is seeing both the sidelights of vessel B ahead, then by definition, vessel B can see both the sidelights of vessel A ahead. And so essentially, the ahead wording replaces the need to specify each vessel. But it's still, in practice, you will engage the rule when both vessels can see both sidelights and not when they can't. And that's Sir Nigel Tear's point in the MSc Apollo.
Okay, thank you.
And so my lord, I was going to mention this when I come to deal with the A vessel point. Obviously, this part of the travel puts me in some difficulty on our principal submission on the A vessel point. But it doesn't affect the fact that our submission, which is why I looked at the overall construction before the grant, but the A vessel point doesn't matter, which is why I said to my Lord Justice Foxton, you need to look at the whole thing as a package. And that's why I keep coming back to the fact that if A can see both sidelights of the other vessel ahead, properly construed what ahead means, geometrically it follows that B can see both sidelights of the other vessel ahead. So there is a built-in need in any event. It's still hardwired into the rule that both vessels can see it. It's just not expressed.
Is there anything else in the Travo?
Two more points if I can. The first requires us, again, to skip forward if we can to Captain Thornton's article.
Tab 23.
Tab 23 at 455. Because during the debate that went on in relation to the changes we've just looked at, when considering the original wording for B23, one of the points made Germany, the German delegation made this point. In paragraph A, head-on situation is defined as follows, and they then set out the original B23 situation. And they say, if, for example, a vessel...
Sorry, which page?
455, bottom right.
Oh, bottom of the page. Yeah, sorry, got that. Yeah.
But the German delegation then point out, if, for example, a vessel is seeing both sidelights of another, 4 degrees on her port bow, she could, according to the above-mentioned wording, so the original B23 wording, conclude a head-on situation. In reality, it is not a head-on situation because the other vessel can only see the port sidelight. It is therefore suggested to return to the present Rule 18 and draft the text as follows. So the German proposal of how to deal with that problem was rejected in favour of the Soviet proposal. But they are describing exactly the situation my lords have in this case if one swaps port to starboard and adds an extra degree to the 4 degrees. The German delegation is saying the original B23 would have said that a vessel 4 degrees to port, my lords in our case 4.9 degrees to starboard, is a head-on situation when it isn't. And the reason it isn't is because the other vessel is not being observed ahead, even if you are seeing both sidelights. My lords, the only other point arising out of the traveller relates to the word appropriate in the last part of the definition being changed to reflect the wording that we actually have in Rule 14C, corresponding aspect. My lords, one of the texts my learned friend has asked to be included in the supplemental bundle deals with that. We don't have it, so at the moment, can I just make the simple submission that a deliberate decision clearly was taken to remove the word appropriate and substitute the word corresponding. And with the French text, as we've already debated, angle. And that adds weight in our submission to the submission that what we are talking about is an angle or an aspect that corresponds to that which is defined by the rest of Rule 14b. So in summary, we submit two things, or three things. Firstly, the Travo do not indicate, as far as we can see, any intention to widen the circumstances in which a head-on situation arises over and above those in which an end-on situation arose. The Travo do show an intention, obviously, to widen the scope of the rule because of the inclusion of 14c, but that is the only widening. The core defining feature is still the ability at night to see both sidelines. And additionally, the texts we've taken from the Soviet delegation make it clear that the text of what became Rule 14b, it was initially part of 14a, but then separated out into its own subparagraph, was intended to be a definition. My lords, can I then move on as quickly as possible to deal with the granular sub-issues? I think the clock on the wall is a little fast, and I put about 8 minutes, but
well, if we start and finish by reference to that clock, if that's all right, then that's probably the best thing. So if we come back when that clock says 2, then that might be a convenient moment. If you're moving on to deal with the definitional and or a vessel points, then why don't we start that at 2? One point that did occur to me, and indeed my lord, during the course of the morning, I know there are transcribers. Is there a plan to get us a copy of the transcript either tonight or first thing in the morning?
check which. It certainly should be either. Or,
Yes.
I'm told probably tonight, but I suspect that depends.
Yes. Okay,
on
fine.
how quickly it will be prepared.
If certainly for me, if that could be sent to my clerk, that would be the best thing. Thank you very much. 2 o'clock on that clock.
All right, the table.
Well, that's the problem, isn't it? It's at 4:30, of course. That's what the robot says. If we're just listening to him crack out, we're just doing Nigel's bit.
Justice Nugee's point on Woodall.
Yeah,
Says could. Says would. Not sure there's anything turns on it, but we
Probably ought to draw it to the attention. Now that you've got the supplementary bundle with us.
How are we doing? So am I likely to get one before the end of the day?
Yes, because if you don't get one before the end of the day, you don't get a reply. You will be on the
Looking forward to having a relaxing afternoon when I could then think about what you've said this morning.
can't leave things here. Why can't you leave it? Good.